This is part 2 of the discussion on sales. In this video, we will learn who are the person that may enter into a contract and the kinds of incapacity. So who may enter into a contract of sale? As a general rule, every person having legal capacity to obligate himself may validly enter into a contract of sale, whether as a seller or as a buyer. However, there are exceptions to this rule. In those cases when the law determines that a party suffers from either absolute or relative incapacity. So that's the two kinds of incapacity. Such incapacity is absolute in the case of persons who cannot bind themselves, such as the minors, insane or demented persons, and deaf mutes who do not know how to write. And relative incapacity exists only with reference to certain persons or certain class of property, such as spouses, agents, guardians, executors and administrators, public officers and employees, and court officers and employees and other specially disqualified by law. So now let us talk about the prohibition with respect to the minors. So generally, the contract entered into by minor and other incapacitated persons like the insane or demented persons, deaf mutes who do not know how to write, are avoidable. However, there are certain exceptions, such as necessaries. So necessaries are those things which are needed for sustenance, dwelling, clothing, medical attendance, education, and transportation according to the financial capacity of the family of the incapacitated person. So if those are sold and delivered to a minor without the intervention of the parents or guardian, he must pay a reasonable price therefore. The contract is therefore valid, but the minor has the right to recover any excess above a reasonable value paid by him. Another exception is the sale by minor. In the case of Mercado versus Espiritu here, the court have laid down the rule that the sale of real estate effected by minors who have already passed the ages of puberty and adolescence and are now in the adult age when they pretended to have already reached their majority while in fact they have not, is valid, and they cannot be permitted afterwards to excuse themselves from compliance with the obligations assumed by them or to seek their annulment. So, what about the rule on the relative incapacity with respect to husband and wife? So, here, the husband and wife are prohibited by law from selling property to each other. A sale between husband and wife in violation of Article 1490 is inexistent and void from the beginning because such contract is expressly prohibited by law. But there are exceptions. So, except when there is a separation of property agreed in the marriage settlements, or when there has been a judicial separation of property agreed upon between them. How about the sale between common law spouses? Is it valid? So the answer is no. The same rule applies here, so it is also null and void. In the case of Galimdim Canules versus Fortune, the court decided that the sale between common law spouses is null and void because Article 1490 prohibits sale between spouses to prevent the exercise of undue influence by one spouse over the other, as well as to protect the institution of marriage. So again, the prohibition applies to a couple living as a husband and wife without the benefit of marriage. Prohibition with respect to guardians. The relation between guardian and ward is so intimate, the dependence so complete, and the influence so great that the transaction between the two parties entered while the relationship exists are in the highest sense suspicious and presumptively fraudulent. This influence is presumed to last while the guardian's functions are to any extent still unperformed, or while the property is still under his control and until the accounts have been finally settled. So here, the contract entered by them is avoidable and can be ratified naman. Prohibition with respect to agents. So here, the agent's incapacity to buy his principal's property rests on the fact that the agent and the principal form one juridical person. Like the guardian, the agent stands in a fiduciary relation with his principal. A sale made by an agent to himself, directly or indirectly, without the permission of the principal is ineffectual. However, the consent of the principal removes the transaction out of the prohibition contained in Article 1491. So now it becomes valid if the same is ratified. So the rule here is that the incapacity of agent is only against buying the property he is required to sell during the existence of the relationship. Therefore, an agent can buy for himself the property after the termination of the agency or other properties different from those he has been commissioned to sell. And of course, the agent may buy property placed in his hands for sale or administration if the principal gives his consent thereto. So, question: can a mortgagee, being the agent of the mortgagor with respect to the foreclosure of property, be a purchaser in his own sale? So, yes, because the prohibition does not apply where the sale of the property in dispute is attached to the real estate mortgage. Because the power to foreclose is not an ordinary agency that contemplates exclusively the representation of the principal by the agent, but is primarily an authority conferred upon the mortgagee for his own protection. Thus, mortgagee can be a purchaser at his own sale. That's the case of Fiestan versus CA. Prohibition with respect to executors and administrators. So the prohibition refers only to properties under the administration of the executor or administrator at the time of the acquisition and does not extend therefore to property not falling within this class. So example, hereditary rights. They are not included in the prohibition insofar as administrator or executor of the estate of the deceased. The executor did not administer the hereditary rights of any heir. Such rights do not form part of the property delivered to the executor for administration. Consequently, an executor may purchase the said hereditary rights. So again, guardian, administrator, agent, the contract they entered into is voidable and can be ratified after the inhibition has ceased. Because the only wrong that subsists is the private wrong to the ward, principal, or estate, and can be condoned by the private parties themselves. Prohibition with respect to public officials and employees. So here, the prohibition refers only to properties belonging to the state or any subdivisions thereof or of any government-owned or controlled corporation or institution, the administration of which has been entrusted to the public officials or employees. Thus, for example, a provincial governor or treasurer entrusted with the administration of property belonging to a province cannot buy said property. But for example, a school superintendent who has no charge of the same is not within the scope of the prohibition. Therefore, he can acquire said property. So we have to note that the prohibition includes judges and government experts who in any manner take part in the sale. So the prohibition with respect to judges and lawyers here, for the lawyers, prohibition against attorneys purchasing the property of their clients in litigation applies only while it is in litigation or the litigation is still pending. So even though litigation is not adversarial in nature, or when it is a certiorari proceeding that may has no merit, it will apply. The prohibition apply. And the prohibition also apply only to lawyer of record and does not cover assignment of the property given in judgment made by a client to an attorney who has not taken part in the case. And this prohibition will not apply to a lawyer who acquired property prior to the time he entered as counsel in the suit involving such property. The prohibition also does not apply to sale of the land acquired by client to satisfy a judgment to his attorney as long as the property was not the subject of the litigation. The prohibition does not also apply to contingency fee arrangement granting the lawyer proprietary rights to the property in litigation since the payment of said fee is not made during the pendency of litigation but only after judgment has been rendered. With respect to judges, to the prohibition on the judges, a judge should restrain himself from participating in the sale of properties. It is incumbent upon him to advise the parties to discontinue the transaction if it is contrary to law. A judge who buys a property in litigation before his court after the judgment becomes final does not violate Article 1491, but he can be administratively disciplined for violation of the Code of Judicial Ethics. So even when the main cause is a collection of sum of money, the properties levied are still subject to prohibition. So just a quick recap on relative incapacity of the agent, guardians, executors, and administrators, public officers and employees, court officers and employees, and others specially disqualified by law. These persons are prohibited from acquiring said property either directly or indirectly, and whether in private or public sale, by reason of the relation of trust with the persons under their charge or their peculiar control over the property. So the disqualification imposed under Article 1491 on the persons enumerated is grounded on public policy considerations which disallow the transaction entered into by them in view of the fiduciary relationship involved or peculiar control exercised by these individuals over the properties or rights covered.